Good morning, everyone. Welcome to our webinar today on effective complaints handling for academies and maintained schools. Thank you for coming and joining us in what will be a brief overview of the main duties in relation to complaint handling. And this relates to school-based complaints from parents. Colleagues from the independent sector that are joining us today are entirely welcome to stay. They may still find the training overall useful insofar as we will talk about best practice generally in the context of complaints. We as VWV have seen a sharp rise in parental complaints, including very complex complaints from parents in the recent year or two. Some of those complaints are brought via the complaints procedures, and unfortunately, some of those are aired in social platforms and so on by way of petitions, etc. And schools are having to deal with those as well. We will touch on how to deal with both types of complaints during our webinar. I guess the overall tenet of the webinar and of all your complaints procedures is that complainants are to be treated equally, fairly, and offered a full chance to state their case either in person or in writing at each stage of your complaints procedure. So once we bear that in mind, Taima, I think we can move to the first slide, which is our agenda for today's webinar. So we will briefly look at the regulations and guidance, then we'll look at complaints policies and what they must contain in accordance with regulations. Then we will be touching on what sort of headings you need to identify in relation to a complaint, how to manage the complaints, terms of reference for external investigators or independent investigators, some discussion of best practice investigations, and then I will look at decision outcome letters, panel hearings or committee meetings, issues for complaints, panels and committees to consider, then a very brief slide on some lessons that trusts and schools can learn during a complaints process. Finally, we'll touch on serial and persistent vexatious complaints and the importance of managing successfully managing complaints. I am joined by Catherine Harris. I am a partner in the regulatory compliance team, and I lead the education law advice for academies and maintained schools. And Catherine Harris joins me today. Catherine.
Yeah, hi everyone. My name's Catherine Harris. I'm a solicitor in the firm's regulatory compliance team, and I assist Miriam on education law matters. So if we move to the next slide, the first thing we're going to look at today is the relevant regulations and guidance that applies to an academy's and maintained schools complaints procedures. So for an academy, the relevant regulations are the Education Independent School Standards Regulations 2014, and that's Schedule 1, Part 7 of those regulations. And you should be aware that under the Academies Act, academies are independent schools. And the main difference between an academy and an independent school is that an academy is funded by the DfE via their funding agreements, rather than via a contractual relationship with the parents. And that means that the independent school standards regulations do apply to academies. And it's Part 7 of those regulations which set out the manner in which complaints must be handled by academies and the requirements for their complaints policies. The Department for Education has published best practice guidance for academies' complaints procedures, which I'm sure people working in the academy sector will be aware of. And that is very useful guidance, in particular because it sets out what the requirements are under Part 7 of the regulations and how academies should be meeting these in relation to its complaints procedures. For maintained schools, it's the Education Act 2002 that applies, and that sets out that all maintained schools and maintained nursery schools must have and publish procedures to deal with all complaints relating to their school and any community facilities or services that the school provides, for which there are no separate statutory procedure. And they must also have regard to any guidance given from time to time in relation to England by the Secretary of State, and that includes guidance from the Department for Education. And as for academies, the Department for Education has best practice guidance on complaints for maintained schools. and that is called the Best Practice Guidance for School Complaints Procedures 2020, and that sets out how maintained schools should handle complaints and the requirements of their complaints procedures. Next slide, please. So looking now in a bit more detail in terms of the requirements for a complaint policy for both academies and maintained schools. So as you'll all be aware, all schools must have a complaints policy. And although the policies must be made available to the parents, they should also help staff to know the correct procedures to follow in the context of a complaint, and also to help staff deal with complaints in an efficient and streamlined way. So if anything isn't clear in your complaints policies, then you really need to address this as soon as possible to ensure that they're compliant with the relevant requirements. And we say this because we have seen instances where schools don't actually have a complaint policy that's relevant for their setting. And normally that's because the Department for Education does have two separate model complaints policies, so one for an academy and one for a maintained school. And we've seen cases where it's obvious that someone's obviously put into a search engine Department for Education model complaint policy for schools, and they've actually downloaded the one for a maintained school when they should have chosen the one for an academy and vice versa. So it is really important that you have a policy that meets your particular requirements depending on what kind of school you are, because these are different. So for an academy, as I've said, the Part 7 of the Independent School Standards regulations apply. And these set out that a complaints policy is in writing and it must be made available to the parents of pupils. It must have clear timescales for the management of complaints. And these timescales are for the schools to set, but they must be realistic and reasonable. A complaints policy for an academy must have at least 3 stages. So first of all, there should be an informal stage, and that allows for the complainant to raise the complaint in person, in writing, or via a phone call with the appropriate person to resolve their complaint. And generally, at an informal stage, that would involve a meeting with the parent. Then it must have provision for a formal stage, and that allows for the complaint to be made in writing. And then it must also allow for the provision of a complaint panel hearing. And the complaint panel must be made up of at least 3 members who have no prior connection with the complaint. And one of those members must be independent from the management and running of the school. So for an academy, as I said, you must have at least 3 stages. You can have more stages, and we have seen instances where academies have 4 stages. So for example, they might have a review stage after the formal stage, but before a complaint panel hearing by someone like an executive head teacher. But you might actually find that it's just more onerous for the school to have more than 3 stages, and our own template complaints policy just has the 3 stages. For a maintained school, the independent school standards regulations don't apply, and there are less strict requirements for a maintained school's complaints policy, but they must still be simple to understand and use, impartial, non-adversarial, enable a full and fair investigation, and it must also respect confidentiality where necessary. And unlike for an academy, for a maintained school, they are free to choose the number of stages that make up their complaints procedures. But the Department for Education recommends at least 2 stages, and that would be a formal stage and then a complaint committee meeting, which is made up of the governing body. And Miriam will come to discuss the differences between a complaint panel hearing for an academy and a complaint committee meeting for a maintained school shortly. But essentially, a complaint committee meeting is an appeal stage, which looks at the complaint afresh. Moving on, please. So we're now going to look at your first steps and what you should be thinking about and doing when you first receive a complaint. And at the outset of a complaint, when you first receive one, it's really important that you analyse the matters raised in the parents' communications and break these down into separate, distinct elements or areas. So, and that's because it's important to identify, first of all, what someone is complaining about, and then secondly, whether the thing that they're complaining about is something that would fall inside or outside the scope of the school's complaints process. So part of this is going to involve identifying particular request matters that need to be dealt with under separate processes. And we recommend that your school's complaint policies set this out. So for example, things that would fall outside the scope of the complaints policy would be subject access requests, freedom of information requests, representations about exclusions, safeguarding concerns, matters that invoke a separate HR process. So that's things like staff conduct complaints, staff grievances, and whistleblowing. We would just say, however, that often complaints are about the conduct of staff, and most of the times HR policies won't be triggered straight away. So you would be able to deal with the complaint about a staff member as a complaint. And then once you know the outcome of the complaint, you would need to consider whether any HR processes such as a capability or disciplinary process would be triggered. But there are some situations where a complaint is so serious that the HR policy would be triggered immediately. And it's always a good idea to check with the HR team whether they are happy for you to deal with it as a complaint or whether separate HR processes will also be ongoing. And then school admissions and education, health and care plan consultations are also matters that would fall outside the scope of the school's complaints policy. Something also that we wanted to flag, which isn't on the slide, is just conflict between parents. So conflict between estranged parents over the application of parental responsibility is a common cause of complaints made to academies. And that's not something that would normally be dealt with as a complaint. And in those cases, we would advise that you set out the legal position to both parents in a letter, and also to inform them that disputes between parents are private matters that should be settled between them or in the family law courts, and that it's not the role of the school to mediate between parents where there are parental disputes. And the Department for Education does have guidance on understanding and dealing with issues relating to parental responsibility, which provides further information on that. In the next slide, we're going to look at a few matters that fall outside of the scope of the complaints policy in a bit more detail. And that's because it's important to recognise when things fall outside of the complaints policy, and that's even if the parents say that it is a complaint and that it should be dealt with under the complaints policy. And then just before we look at subject access requests, just one more point to make is that at the outset of a complaint, you should also be thinking about whether or not you have sufficient information from the parents or whether more information is required to try and understand what their complaint actually is. And that's because it's sometimes just not clear what a parent is complaining about. And it might be the case that you need to get more information from them. And so sometimes it's a good idea to have a meeting with the parent in the first instance to confirm your understanding of the complaint and whether actually you need more information from them. So looking now at a few of the things that I've mentioned that would fall outside the scope of the complaints policy, and I'm only going to look at subject access requests, freedom of information requests, and representations about exclusions in a bit more detail. And that's because these are what we find are frequently raised as part of a complaint, or which schools can sometimes mistake as something that would fall within the scope of the school's complaints policy. So the first one is a subject access request known as a SAR. And I'm not going to go into loads of detail because this isn't a data protection webinar, but this is just to give you a bit of information so you can work out what a SAR is to be able to identify if a parent makes one as part of the complaint. So SARs include requests for your own personal data, but they can also include a request for a parent's child's data, and that's where a parent would make a SAR on behalf of their child. And this is very common in a school because, for example, if a parent is making a complaint about a detention that was imposed on their child, they might ask for something like the child's behaviour record, but that actually contains the personal data of the child, not the personal data of the parent. And importantly, the Information Commissioner's Office states that a child may exercise their data rights on their own behalf as long as they are competent to do so. And the age of 12 is generally considered as the age that a child would be competent to exercise these. So what that means is that parents are normally able to make a subject access request on behalf of their child where they are under 12, but where the child is over 12, the child would need to give their authority for the parents to make a SAR on their own behalf. And that would mean that the school would need to get the authority from the child, either by sitting down with them in a meeting, explaining what the parents have requested, and then seeking their authority in relation to that, or asking for the child's written authority. A SAR does not have to be made in writing, so it could be raised in a meeting, and the time limits do not run in school days. So you would have 1 month to respond to a SAR, and you don't get extra times for weekends or the holidays. And sometimes it might be the case that a SAR is made in the school holiday, but you would still need to respond within 1 month. And you can get an extension for 2 months to respond to a SAR, but that's only in very limited circumstances. This is complicated though, so please do seek advice from your data protection officer. As I said, all I wanted to do is flag that you need to be alert that parents may make a SAR as part of a complaint, which would not be dealt with under the school's complaints policy. And my colleagues in our information law team are actually also delivering a data protection webinar for the AMS sector, which is planned to take place in July, which will cover SARs and freedom of information requests. So please do look out for that. Next slide, please. So I mentioned freedom of information requests, and which are known as FOIAs, and this is also a request that might be made as part of a complaint. So a request for any recorded information that is not a SAR should be dealt with as a FOIA, unless it can be dealt with in the normal course of business. An example of a FOIA might be when parents write in and say something like, I want to know how many boys have been excluded this term compared with girls. But other things they might ask for are things like school policies, minutes of meetings, information about staff, statistical data about pupils, and other statistical data and general information. FOIAs must be made in writing, and you should respond promptly and within 20 school days. We do have a specialist information law team that can assist with SARs and FOIAs if needed. And both SARs and FOIAs do have statutory deadlines to respond to, so all staff should be trained to recognise them and then pass them immediately to the person trained to deal with them. And normally that would be the data protection officer, and that's to make sure that there aren't any delays in dealing with these requests. Next slide, please. So something that is often mistaken as a parental concern that should be managed under the school's complaints policy are representations about exclusions. But complaints about a suspension or permanent exclusion are actually known as representations about exclusions, and they need to be dealt with in a very specific way, which is set out in the Department for Education's statutory exclusions guidance. Most people on the webinar will be aware of the guidance, and the head teacher of a school must be familiar with this because they're the ones with the power to exclude. But importantly, representations by parents in relation to a pupil exclusion must be considered by the governing body, but the manner in which they are considered and the timescales that relate to this completely depend on the type and length of the exclusion. I'm not going to go into this in any more detail, as we could do a whole separate training session on the statutory exclusion process. But the point really is that a representation about an exclusion, be that a suspension or a permanent exclusion, would not be dealt with under the school's complaints policy. Next slide, please. Looking now at a case study, because we thought that it would be helpful to apply some of what I've said through a case study. And ordinarily, if we were delivering client training, we would give clients, 15 minutes or so to look through the case study and then feedback on their thoughts. But unfortunately, we don't have the time for that today. So I'm going to read through the case study and then take you through some of the headings of complaint and then what we would expect would not be dealt with under the school's complaints policy. So in this case study, there is an email from Mrs. Brown to the head of year, and she says, I'm very unhappy that my son Billy has been given 3 detentions in the past 2 weeks for being late, when you are fully aware that he has to drop his sister off at juniors first because I start work at 8 a.m. Mr. Daniels has now given Billy a 3-day suspension for not attending the last 2 detentions after I told you he would not be attending. This is discrimination, and I am going to report you to Ofsted. I want to know how many other kids have been given detentions for being late and what their ethnic background is. I bet they are all black like Billy. Please send a copy of Billy's behaviour record so I can give this to my lawyer, who is going to issue a claim against you in the High Court. I will be claiming compensation from you for discrimination against Billy. Next slide, please. So in terms of the elements of the complaint, you might think that the first paragraph raises a straightforward complaint because the parent has clearly said that they're unhappy about something. But what you'll see when you actually read the paragraph in full is that the parent is actually complaining about a suspension, and it's therefore a representation about an exclusion, which therefore triggers the statutory exclusions process. I just wanted to flag that you might think the first sentence should be dealt with under the complaints policy because Mrs. Brown is complaining about the 3 detentions, and complaints about detentions would normally be dealt with under the school's complaints policy. But you should find normally that when parents make representations about exclusions, they will also likely complain about the circumstances that led up to the exclusion. And in those circumstances, you need to consider whether it would be appropriate for the governors to consider everything under the statutory exclusions process, or whether there's actually parts of the issues that the parent raises that you need to sever off to be dealt with under the complaints policy. We'd say it's generally better if the governors can deal with everything under the statutory exclusions process, and that way you don't need to invoke the complaints policy separately, but it really depends what the parent is complaining about. And here it's clear that the missed detentions are background information for the suspension. You'll see that the parents also made a freedom of information request because she wants to know how many other kids have been given detentions for being late and what their ethnic background is. And that's a freedom of information request because it's a request for recorded information that is not a SAR, because Mrs. Brown is not asking for the personal data of themselves or their child. And then she also makes a subject access request because she asks for a copy of Billy's behaviour record. So here it's not clear how old Billy is, and therefore whether or not you'd need Billy's authority to disclose the behaviour record to the mother. But what I would say is that Mrs. Brown is asking for this behaviour record in the context of a suspension. And in respect of suspensions, parents have the right to be notified of the suspension and then submit representations in relation to these. So it would probably be very unlikely that you wouldn't disclose the behaviour record to the mother because she needs to have all the relevant information to be able to prepare her representations if she'd like to make them. And then just to flag that there are litigation and regulatory risks. So she's obviously alleged discrimination, and that needs to be taken very seriously. We would normally advise that where you're alerted to circumstances that might give rise to a possible discrimination claim, you notify the school's insurers of this straight away. And most schools' legal fees should be covered for defending discrimination claims by the insurers. So you do need to notify them once you're alerted, but you would obviously need to check your policy wording in relation to this. Next slide, please. So looking now at managing complaints under a school's complaints procedure. So setting aside anything that should be dealt with under a separate process, once you've worked out which elements of the parents' correspondence is to be dealt with under the school's complaints policy, you need to think about how their complaints are going to be managed. So first of all, you should think about whether or not the complaint is against the school, academy, or trust or federation. And that's because it might be the case that you actually have 2 separate complaints policies. So you might have one policy which is for school level complaints in relation to the action or inaction of the school, but you might have another policy in relation to trust or federation level complaints. So for example, complaints about the trust board, CEO, or executive team. So you obviously need to make sure that you're looking at the right policy that applies. You should then think about what stage the complaint should be dealt with. And I've already discussed the different stages under the complaint policies for academies and maintained schools. You should think about what the parent's desired outcome is, and that's what the complainant is seeking. And in particular, that's important because the best practice guidance for both academies and maintained schools says that you should ask the complainant at the earliest stage what they think might resolve the issue. You should consider whether there's any staff that are subject to the complaint, and if there are, you should make sure that they are not involved in any investigatory or decision-making role. And that's because anyone involved in an investigatory and decision-making role should be impartial. And your procedure should really set out in your policy who should be dealing with the complaint where there is any conflict. So for example, if there is a complaint against a head teacher, then obviously the complaint shouldn't be investigated by the head teacher. and we would normally expect that it would be dealt with by the chair of governors. You need to think ahead and keep individuals clean for a complaint panel hearing or a complaint committee meeting if needed. So, for example, if the chair of governors have investigated the complaint at the formal stage, then obviously they shouldn't then be involved in investigating the complaint further and being involved in the complaint panel hearing and the appeal committee stage. And that's to ensure that those considering the complaint at the different stages are impartial. And if there's any doubt as to a person's ability to act impartially, then they should withdraw themselves from considering the complaint. You should also identify and establish the different roles and consider whether or not there needs to be a separate investigator or decision maker. And that's really in relation to the formal stage, where the role of the investigator is to investigate the complaint and the investigation report. And the role of the decision maker is to consider the investigation report and then make their decisions. So whether or not the complaint would be upheld or not upheld, and any relevant recommendations. It might be that the investigator and the decision maker are the same person, but sometimes they can be two separate people. So, for example, if a head teacher is the decision maker, they might actually not have time to do the investigation, and they might decide that they want to delegate the role of investigator to someone else. You should think about whether there's any specific terms of reference for the investigation required, and we'll look at that in the next slide. And then you should also think about whether or not you would benefit from an external investigator. And that might be appropriate. For example, if you know the investigation is going to be very time consuming, you might want to commission someone externally to do the investigation, just so it's done in a very thorough way. You might also want to commission an external investigator to ensure that there isn't any bias in the proceedings. And that's important because the appearance of bias might also be sufficient to taint a decision. And there is the public law principle that justice must not only be done, but also seen to be done. And then you must also ensure that all relevant evidence is retained and easily accessible in one place. And that's in particular because during the investigation, the investigator will be collating his evidence and findings, and the complaints panel will normally want to look at all the evidence that's been gathered during the investigation at the next stage if it proceeds to that. Next slide, please. So looking very briefly at a terms of reference, and a terms of reference is a document that's prepared by the decision maker at the formal stage for the investigator, and it's to provide instructions on the purpose and scope of the investigation to the investigator. If it happens that the decision maker and the investigator are the same person, then you probably don't need something that's quite so formal, but we would say that it's still useful for the person investigating, even where they are also the decision maker, to have something similar because it will help keep them on track for the investigation. And a terms of reference should be tailored appropriately to reflect the specific case facts, and also depending on who the investigator is and how much experience they have. So a terms of reference would set out the relevant background information. That would include the headings of complaint that the decision maker has distilled once they receive the parent's correspondence in relation to what their complaint is. And it should provide them with status and scope of the investigation. So generally, the scope is for the investigator just to make findings of fact. So that's whether or not something did or did not happen based on the balance of probability. And then it would be the role of the decision maker to make their decisions and recommendations based on this. And we would generally advise that the investigator doesn't make recommendations, as that's normally the role of the decision maker. And that's especially where the investigator is external. And that's because an external investigator is not going to be familiar with the structure of the trust and federation and all of the school's relevant procedures and practices. The terms of reference will also set out the purpose of the investigation. So that's to undertake a full, fair and impartial investigation, and also to produce a written report into the complaints made. It should provide a list of the documents and witnesses that the decision maker wants the investigator to speak to, but it should also make it clear that the investigator should follow the evidence, which we'll come to look at in the next slide. It should provide information on what the decision maker wants to see in the investigation report. So that might be things like the investigator's methodology, a list of the headings of complaint, the key evidence that the investigator has gathered, any key findings of fact, and the investigator's factual conclusions. And then it should also make a point about confidentiality. And the terms of reference is generally a confidential document that would not be shared with the complainant, but it should be drafted on the basis that it might end up being disclosed. So for example, if the complainant makes a subject access request or it ends up being considered by a third party. And then it should also set out the timescales for an investigation. Just to flag that we do have a complaints administration pack, and that pack contains template documents to be used throughout the lifespan of a complaint. And the pack does include draft terms of reference, which our clients find to be very helpful. The pack is available to purchase and is at a discounted fee for our retainer clients. So if you have any questions about the pack, do please let me and Miriam know after the session. Next slide, please. So just a final slide before I hand over to Miriam. And I'm just briefly going to touch on best practice investigations. And I would say that we could do a whole separate session just on best practice investigations. So this is just really some of the key points. And as I said, the investigator will be looking at the relevant evidence so that they can make findings of fact on the balance of probabilities. And balance of probabilities means, is it more than 50% likely than not that something happened? So for example, if the evidence shows that it's more than 50% likely than not that a pupil hit another pupil, then the finding of fact is that that did happen. In terms of evidence that the investigator will need to consider, they'll need to think about the witness interviews that it will need to undertake with the relevant staff, pupil and/or parents. And it is really important that the investigator makes a record of any witness interview that it undertakes as part of the investigation. And in particular, that's because the complaints panel and complaint committee will need to be able to access the evidence at a later stage if it progresses to the next stage of the complaints policy. In terms of witness interviews, the investigator should also think about whether any reasonable adjustments are needed for the interview, and the pupil might also need to be supported by an unconnected staff member that they trust. And as you'll be aware, the investigator should not ask leading questions. So that's questions that suggest the desired answers, because the investigator should be acting impartially and in good faith. Other evidence that the investigator might need to look at is CCTV and mobile footage, documents and records, and they should have been listed in the terms of reference, relevant school policies, medical evidence. So for example, if there's been an injury, you might want to look at medical evidence. So for example, to confirm that the pupil went to hospital if the parents said that they did, and that's to confirm whether or not what the parents said is accurate. And then you might also need to look at information from the police. And just to flag here that if there is an ongoing police investigation for any reason, you should liaise with the police and children's social care if needed to check that the school's investigation does not prejudice the police's investigation and any subsequent possible prosecutions. And the investigator should look for evidence that supports and undermines stated positions. So they should speak to both sides in sufficient numbers. That's to ensure that there is no appearance of bias. And they should also explore accounts and follow the evidence. So when you're investigating, you might think, you might discover evidence that comes to light that you didn't realize was there, and that might lead you in a completely different direction. And if new evidence does come to light, then you will need to investigate that. And that might involve going back to witnesses to ask further questions, just to gain clarity on certain points or to get their side of their account in terms of any new evidence which appears. And as I said, the terms of reference should suggest what the investigator might want to look at, but that the investigation should go wherever the evidence leads them. Just a final point, investigations can be very time consuming, so do make sure that you set aside enough time to undertake the investigation and produce an investigation report. The whole process might take weeks, depending on the nature of the complaint and how many issues the parent has made. And if there's any reason that the school can't meet the deadlines set out in the complaints policy, then they need to inform the parent of this and the reasons for the delay. And I'll pass this over now to Miriam, and she's going to take you through outcome letters.
Thank you, Catherine. I've been trying to answer some of the questions live. There are still a few in there. Now, with relation to in relation to decision and outcome letters, the first point to note there is that when you're preparing a letter, when you're drafting a letter, your decision maker is drafting a letter, it should be a useful standalone document. So whoever picks it up later on and down the line should be able to tell what the complaint was about, what was done about it, how it was investigated, who were the parties, and what the decision made was. Sometimes we find that outcome letters are very, very brief and they simply say, we've considered your complaint, we uphold it or reject it. But that means that the next stage decision maker, if there is going to be a next stage, will not be able to understand why the decision was made. And indeed, the parents may be confused as well. So it's really important that the letter is a substantive document. In the title of the letter, do please confirm the stage of the complaint so that that's clear to parents and as well to any outside reader if there is going to be one, for example, the DFE later on down the line or Ofsted. Include the relevant date. The complaint is useful in general for parents to include numbered points and headings and use this consistently throughout. It is also useful to set out how it was investigated, so who conducted the investigation, who the investigator was, who was interviewed, and any reference to an investigation report should be included there. All the decisions that are made within each heading of complaint should be made in the balance of probabilities. So if you have a complaint that the school has not communicated sufficiently with parents on a particular point, you will be making a finding as to whether it was more likely than not that the school have not communicated effectively with the parent, and then making that finding. In relation to the finding, it's very important to tell parents whether you're upholding the complaint in full or partially, or whether you are dismissing or rejecting the complaint, and if so, whether in full or partially. You can uphold one element of the complaint and say that you do not uphold the other elements. We normally advise the schools that after each heading of complaint, after the consideration of each heading of complaint, the decision maker inserts a recommendation. So if they have upheld an element of the complaint, partially or in full, they will be saying, in relation to this failing, I recommend that school, for example, improves their communication strategy with parents, etc. So it's important for parents to know what the school is going to do about it. And the reason for this is that it reassures parents that they have been heard and that things are going to change at the school. At the end of the letter, please do not forget to tell them what the next stage is, if there is to be one, and how they can progress, either internally or externally. Next slide, please. What the decision letter should not do, it shouldn't simply say that you've upheld or not upheld a complaint without telling them why. So you need to give reasons, and that's a fundamental principle of fairness, that if you're making a decision on something in relation to a complaint, the complainant needs to know why you have come to that decision. You shouldn't pass comment or consider anything outside the remit of the complaint. Sometimes we find that decision makers stray outside the remit of the complaint, and that's why having those headings in bold, numbered, is very important, so that they don't start looking at other extraneous issues that have not been raised as part of the complaint, and that could open a can of worms for the school. If you have sought legal advice in relation to the complaint, please do not say so in your outcome letter. That has unintended consequences that we don't have time to talk about, but please just do not make reference to the legal advice that you have received. And finally, a reminder that outcome letters have to be parent and pupil friendly. So there is case law now from the High Court indicating that where a document relates to a child and the rights of a child, and that pertains to that child's education, well-being, etc., the document must be readable to families. Obviously, this is a judgment call depending on the subject matter of the complaint and the age of the child. The extent to which you will make it parent and child friendly is a balance. to be struck. But it's important that there is no jargon, there are no acronyms, that parents can understand it in plain English. And moving on to the next slide, Taima, which is on complaints panel hearings for academies and complaint committee meetings. There are some slight differences in focus between these hearings in relation to whether it's an academy or a maintained school. In academies, the panel will consider the elements of the complaint that remain outstanding. So it may be that the parent has chosen to escalate only one or two elements of the complaint, whereas in maintained schools, the appeal stage is a full review, and they will consider the complaint afresh, as if nobody had looked at it before. In academies, the panel will be appointed by on behalf of the trust board. It will consist of at least 3 members. One of the members needs to be an independent member, and this is a question that we're very often asked: what is an independent member? Well, an independent member is somebody that doesn't have management or control over the day-to-day dealings of the school. In relation to multi-academy trusts, the guidance is clear that multi-academy trusts can appoint a local governor from a different school within the MAT who has no conflict of interest, because that person hasn't been involved in the complaint or with the parent or knows the member of staff separately, etc. Because the member of a local governing school would have had no direct involvement with the management and running of the school being complained about. All of the members of the panels must be unconnected and impartial, and that is because one of the fundamental principles of fairness is that there is no bias in the decision-making process. So they must not know the parents or have any potential conflict in relation to the parents of the child, the member of staff, and the subject matter of the complaint. Remaining members other than the independent panel member can be, but do not have to be, governors or trustees. In relation to maintained schools, the complaints committee meetings is a committee of the governing body that comprises of at least 3 governors. Again, they must be unconnected and impartial, so there is no actual or apparent or an appearance of bias. And if the entire governing body has been compromised for whatever reason, then an independent committee can be appointed in that case. Now, just pause there in relation to the panel hearings. Quite often we see that when complaints are coming towards the panel hearing stage, parents are starting to speak about bringing legal proceedings against the school or the trust. It is at that point that the trust of the school needs to pause and think whether it is necessary to pause the complaints procedure if the parent has or is about to commence legal action. And it will also be necessary for you to consider whether you need to notify at that stage your insurer. And the guidance is clear that if the parent actually does commence legal action, schools are entitled to suspend the complaints procedure until legal proceedings have concluded. So if there is any intimation that that is about to happen, you need to consider that carefully before moving forward, because you may be jeopardizing your legal insurance by proceeding with your complaints procedures. If the school or the trust employee is a witness, they're entitled to bring a union representative or a legal representative due to the potential ramifications on employment matters of the hearings, and there is that should be allowed and supported. You can suggest alternative measures, for example, a different member of staff to attend with them as support, or an external support person, etc. But that is in consultation with the employee, of course. In all cases, both maintained schools and academies can refuse the recording of meetings. unless there are reasons for that recording, because for that recording to be necessary. For example, under the Quality Act, where you have a parent, say, that has dyslexia, the parent may request to record the meeting because it's easier for them to then access the information that was said at the meeting. So, but you have discretion as a school to decide for yourselves whether to allow complainants to record meetings if it is not required for the purposes of a reasonable adjustment under the Equality Act. Again, often we see panels being asked to consider recordings by way of evidence. So they say to the panel, can you consider this recording, which was generally covert, and it proves my point. The DfE is abundantly clear that they will support a school's refusal to accept as evidence recordings of any conversations that were obtained without full permission of all the parties being recorded. Meeting minutes. Parents are entitled to a copy of the meeting minutes, and therefore it's important that you check this carefully before these are approved by the panel or the committee, and parents are entitled to it. They can either make a subject access request or a request for the meeting minutes. Some schools decide to release the minutes alongside the decision. That's entirely up to you, but so that you note that parents are entitled to the minutes. And a reminder that complaints must be kept confidential and information shared only on a need-to-know basis. So details of the complaints will not be shared with the whole governing body at any stage while they are being considered. And even after they have been considered, you can share the fact that a complaint has been made, but not the full facts behind the complaint. So moving on now to the next slide, where we would look at the issues that both these panels will have to consider. So they will consider what issues remain in dispute for academies, and for maintaining schools will review the entire decision. They will consider who needs to attend and whether any policies are engaged, and if so, download the policies, read them carefully, make sure that they have been followed. For example, behavior policies are often relevant in these circumstances, bundles will be circulated prior to the meeting in good time, normally at least 5 working days before the meeting, to allow parents sufficient time to read the documents. Good practice, again, to ask parents whether they want a paper copy of the document, because not all parents are able to navigate numerous pages digitally, and they may not have an iPad, so they may be looking at things on their phone and so on. So please do send your parents a paper copy or ask them to collect one from the office if they do request one. The bundle should contain all the records that are in relation to the complaint up to that point. And you should decide whether anything is missing, and if anything is missing, you need to supplement it. The committee or panel will again decide on the balance of probabilities, so more likely than not that something happened, as parents state, and then they will make appropriate recommendations. And ideally, they would follow the same order as it was followed previously in relation to the headings of complaint, so that parent can have some consistency in how the complaint has been looked at and decided. So now, moving on to the next slide, what lessons can you learn as a school, or should you learn as a school normally? You will record, we generally advise our schools to record what other actions they will take, which are wider actions to address some perhaps systemic failures or failures that where there is a pattern, to record them separately. So what have you done about complaints? Keep a record of that so that you can demonstrate that you're learning from the experiences and that you're improving your practices on the ground where failings have been found to have taken place. You will spend some time thinking about what you could do differently next time and talking to your leaders about what could be done differently. And decide whether any training is necessary, internal or external, on the matters raised in the complaint. And if there is any potential for a follow-up legal action, then you will keep a record of everything that you did in relation to the complaint, as you're obliged to do anyway, for at least 3 years. You'll speak to your insurance if necessary, or to your legal advisors. So now moving to the very tricky matter Next slide, Taima, please. Of serial and persistent vexatious complaints. There is DFE best practice guidance for academies and maintained schools. Once you get the slides, if you click on those entries, you will find it there. The DFE guidance is quite terse in its terms, but it still does provide a fairly sound framework to help you think about whether somebody is a serial or persistent vexatious complainant. Now, the Office of the Independent Adjudicator defines serial and persistent vexatious complaints as obsessive, persistent, harassing, prolific, repetitious, and meritorious, unrealistic, or meritorious but pursued in an unreasonable manner, for example, repetitiously, designed to cause disruption or annoyance, and demands for redress that lack any serious purpose or value to the complaint in relation to the complaint. So in the next slide, we have outlined some steps that some questions that you will need to ask yourselves to decide whether you are able to stop responding to a serial and persistent complaint being raised. If you can say yes to all of the three initial questions, then the likelihood is yes, you can stop responding, other than to say, we have now deemed your complaint to be serial and persistent. And it's the complaint that is deemed serial and persistent, not the complainant. So the three questions are: you have taken every reasonable step to address the complainant's concerns. The complainant has been given a clear statement of your position and there are options. And despite this, the complainant contacts you repeatedly, making substantially the same points each time. Now, there are some additional factors that would make your case stronger in labeling a complaint as serial or persistent, or serial and persistent. So, for example, the complaints are often or always abusive or aggressive. They make insulting personal comments about or threats towards staff. The individual is contacting you with the intention of causing disruption or inconvenience. And anyone, just a reminder, anyone has a right to raise a new complaint at any time. And the fact that a parent has raised multiple complaints doesn't render the complaint as a serial or persistent complaint. And that is because the parent may be raising new complaints, which need to be looked at and considered under the complaints procedure. So it is only where the parent is raising this obsessive, persistent complaints that are intended to harass, that have not been looked at before, etc., that you will generally be in good ground to find that the complaint itself is serial and persistent. Next slide, please. So in terms of managing those complaints, you should not mark a complaint serial before the complainant has completed the procedure. And the application of a serial or persistent marking should be used against the subject of the complaint rather than the complainant. So it is complaint-based and not person-based. In the next slide, we'll look at how we can deal with managing these complaints and things that you can do that may improve your relationship with the parents and their understanding of how you will or will not deal with the persistent complaints. You can enter into a communications protocol or a communication strategy where you tell parents, from here on, we will only communicate with you via a single point of contact, and this communication will take place only once a week. And if for example, your complaints come in on a Thursday and we've said that we'll communicate on the Friday, we may push those complaints to the next week, or you can do it bi-weekly or monthly, whatever you decide. Obviously, there has to always be a caveat in there that if it is safeguard related or urgent, they do have the usual channels of communication. But other than that, if they communicate outside their communication strategy, things might not be responded. You can also suggest communicating through a third party. I don't find this to be very effective, but it's suggested in the guidance. You still have to provide the parent with all the information that they're entitled to, for example, under data protection legislation. And you cannot restrict SAR or FOIA requests simply because you have deemed a complaint to be persistent or serial. If the parent has made a subject access request or a FOIA request, then you must comply with your data protection obligation there. In the next slide, I have inserted some information on complaint campaigns, which we are seeing increasingly either by online petitions or large community groups, in essence, bringing a complaint based on the same subject to a school via very many different channels. They usually come from complainants unconnected with the school. And you ought to have at school a separate procedure in your policy as to how you will deal with complaint campaigns. You can either send separate template responses to all complainants at once, or you can publish a single response on the website of the DFE, and you can signpost the DFE if satisfied. There is nothing in the regulations or the guidance telling us how you are to establish what sort of procedure you need to have for complaint campaigns, but what is clear is that you need to have a procedure, whatever that is, for considering complaint campaigns, for example, in relation to large petitions, etc. So the last slides, just a bit on how important it is to successfully managing complaints. It obviously allows the school to know how to improve. It keeps parent satisfaction high, and it avoids almost complaints, and it also reduces the risk of legal action. We have just a few minutes, and I'm conscious that very many people have posed questions. The last slide, if I may, before I go on to the questions. We've inserted some links here to how we can help. We have complaints templates policies. We have a complaints pack. We can provide advice, draft outcome letters, etc., etc. You are also all welcome to sign up to our free webinars link if you haven't already done so. We have an Academies and Schools law brief, which gives you all the legal advice updates that you need to have in order to remain compliant with all the regulations and other products that you can find there.